Hey, Raindrops. On today's episode of Reality with the King, I got my girl and y'all favorite, Eboni K Williams is back to, look, not back to
And
break
black, and black.
Right. She's black, and baby, we're in the brackets of what's going on with the Wendy and Eddie Osefo case with more updates. But before we get into it, Eboni, how are you, my love?
Oh, I'm doing so well, Carlos the King. Just back from a little Judge Eboni taping in Los Angeles. So I'm back on the East Coast and excited about it. So excited.
A lot of your fans and the Raindrops have been asking about this show. So when can we expect it to come back on the airwaves?
Yeah, so it's syndication. So we love a good syndication because we keep it going. But the brand new episodes, those should top of the year, they can expect brand new episodes of Judge Eboni.
Okay, good. So listen, Raindrops, we're in for a Christmas tree. Our gift is more episodes at the top of the year. So look, let's get right into the latest update, Eboni, as it relates to what's going on with Wendy and Eddie and their alleged crime of insurance fraud. So the latest update is this. Wendy Osefo accuses police of illegal arrest as she demands the fraud charges be dismissed. Mm-hmm. So Raindrops, what's going on right now is Wendy demanded the same of wire and verbal communications due to an allegedly unlawful interception, also claiming that unlawfully obtained admission statements or confessions should not be allowed as evidence in court. She also requested that the trial of co-defendants be severed from the trials of the defendant, meaning she wants her and Eddie to be tried separately. So listen, Eboni, we have a lot to talk about, but before we get into all of that, explain to me, why is now Wendy alleging that the charges should be dropped? Because in her words, or her attorney's words rather, she is alleging that it was an illegal arrest.
Okay, so we're going to zoom out for a second, Carlos, because this it's dense and it's meaty and it's all very standard, actually. So I want Raindrops to know that this is not wild, beyond scope type of behavior from a case of this nature and this magnitude. So as a defense lawyer, our job is to defend our clients zealously in every legal parameter available to us. So there's basically two ways in which we tend to do that. The substance of the case, okay, so that's kind of what we see at trial. They literally didn't do it. But before we get to that, there's a great opportunity, and any defense lawyer will tell you this, Carlos, to get rid of the case, so to speak, eradicate it, beat the charges, so to speak, before we even get to trial. And it's these types of pre-trial motions. So that's what y'all are looking at, Raindrop. This is a standard pre-trial motion that doesn't even get to whether they actually did this or not. This is simply saying that the way in which these charges even came about are illegal at the onset. So this is procedural, okay? This is where the procedural pre-trial procedural stage. And Wendy, through her attorney, is saying that pump the brakes. We don't even need to get to a trial, because the way in which my client has even faced charges, the way y'all collected this evidence, the way that you have actually charged her with these crimes is illegal. And it's illegal per the Fourth Amendment of the Constitution of the United States. So the Fourth Amendment, amongst other things, Carlos, protects all of us from being free from illegal searches and seizures. Okay, so this is the search and seizure clause, amongst other things, but that's the biggie. So that says that no government entity can invade our privacy, can take from us, can search our person or home or car or anything without probable cause. So that's another big legalese word I want y'all to stay with me on. Probable cause. What is probable cause, Carlos? Probable cause is a requirement. Before you start searching and patent and all of this, You have to have a reasonable belief. Law enforcement, I'm talking about, the cops, the sheriff, whatever the law enforcement, the FBI, whoever is acting as law enforcement in the case must have a reasonable belief, okay, that criminal activity is afoot, that a crime has, they can't just out of the clear blue sky walk up to you off the street, Carlos, and start patting you down and going through your car and all of this, that, and the third. And let's say they find contraband, drugs, weapons, whatever. Now you're arrested. Well, if I'm your lawyer, I'm getting all that tossed out and my client is walking away free because you had no probable cause to stop Mr. King. Now, what does probable cause look like? Basic example, most people are maybe familiar with or someone they know, the odor of marijuana. So let's say you're driving down the street and you're speeding, not speeding, because speeding's probable cause because that's a crime too, or an infraction. But let's say you're driving the speed limit and the cop pulls you over. Hey, Mr. King, hope you're well, license and registration. As you hand over license and registration, Carlos, if that officer claims to smell the aroma of marijuana, okay, or sees maybe something that looks like contraband in plain sight in your vehicle, that can serve as the probable cause. So going to the, and then that allows everything that comes after that, the search, the seizure, the arrest potentially, they're all legal because they are respecting the Fourth Amendment, because the probable cause requirement, reasonable belief that crime is afoot, has been satisfied. Going to Wendy, her lawyer, Carlos, is saying, I don't care what y'all say y'all have on my client. I don't care what audio tapes, what emails, what alleged confessions, what statements she may or may not have made to officers or investigators against her interests. Y'all can't use any of it. It's all illegally obtained because it is all gathered in violation of her Fourth Amendment constitutional rights. They are arguing illegally, she has had illegal searches and seizures afoot. Is that making sense?
No, it's making sense, because the thing is this, what you're saying is, look, any lawyer, right, would their first step is to make sure. Yes, this is the first step to make sure that we do not want to go to trial, and let's try to enforce something where all charges can be dropped so that a trial is not, does not occur.
Yeah.
Yes. So any lawyer would first say, look, let's look into the Fourth Amendment, the search and seizure clause, to make sure that I don't care what you allege you have on my client, we are considering this as a way of saying that you guys illegally searched her home. Because again, I want to make it very clear, and I'm going to get to the rest in a second, this is only Dr. Wendy's attorney.
Correct. We're not talking about Eddie at all, Raindrops. We're going to get to Mr. Osefo, the Eddie of it all, in a minute. We are strict, and this is very important, that as you said in the intro, Carlos, there's already been a request from Wendy's legal team to bifurcate, sever the trials. They do not want Mr. and Mrs. Osefo tried jointly. I'm sure they have reasons for that, great reasons, I'm sure. They want them tried separately. So Wendy has a lawyer, and then Eddie has a lawyer, and they are separate counsels. They will not be collaborating on this matter. Go ahead.
So the thing with that is, okay, because we're going to get to that in 1 second. When it comes to Wendy's lawyer making this proclamation, do you think, just based on the facts that we know it to be as of today, do you think there's probable cause for this Fourth Amendment to stick?
Yeah, it's so hard to speculate, Carlos, because we can't see what they would have cited as the probable cause. Now, it could be, now I will say to Raindrops, it's not a very hard burden to reach. Probable cause just means more probable than not, right? We call it 51%. It's not proof beyond a reasonable doubt. That's a trial standard, okay? That's not the standard. The standard is reasonable belief that a criminal activity is afoot. So it could be the testimony of one of the investigating officers from the alleged home burglary saying that, well, we're not seeing any evidence of a third party breaking and entering. So that gives us reasonable suspicion. See how we're possibly getting there? That fraudulent activities are taking place. That is an example, Raindrops. I'm not saying that's what they're citing as their probable cause. That would be an example. It could be a litany of things. It could be that somebody testifies that they saw some of the garments on social media or this or that, and that triggered a reasonable suspicion to go back to the inventory documents of what was claimed to be stolen, and upon comparison, there's a discrepancy. That's an example of what the reasonable cause could look like. Now, I want to make clear this too, Carlos. When the Wendy's lawyer is asking for all the evidence, it's also a suppression motion, right? So it's a dismissal motion. I'm asking for all charges against my client to be dismissed because I'm alleging that this was an illegal search, a violation of her Fourth Amendment right to protect against illegal searches and seizures, and also any and all evidence, as you laid out, Carlos. We're talking about potential emails, wires, audio tapes, polygraph results, anything, all the evidence. We're asking for all of that to be suppressed, including confessions. I thought that was interesting, including any alleged confessions or statements against their own interest from Ms. Osefo. We want all of that suppressed, Your Honor. We don't want any of that being used as evidence at trial, if there is a trial, because we are saying that that is what we call fruit of the poisonous tree. Fruit of the poisonous tree. Let's go back to Adam and Eve, ladies and gentlemen. Yeah, fruit of the poisonous tree is a legal doctrine that says anything gathered under a defective search warrant, or it is seized under a defective search warrant, is rotten, is tainted, it's poisonous. It means it could be totally good evidence. It could really prove the veracity of the claims, but because it was gathered and collected under a defective, unconstitutional way, throw it out. It must be all thrown out. The evidence now becomes as deficient as the charging document. Is that connecting?
Oh no, it's connecting majorly. So Raindrop, just to sort of like sum it up for you guys too, what Eboni is saying is, look, Wendy's lawyers in a separate filing, she asked the prosecutors for all alleged evidence, a list of witnesses, polygraph results of the witnesses, the names of any confidential informants, and copies of the police reports, because what the lawyer is saying, even if this, look, regardless of what you have, the basis of this being an alleged illegal search removes all evidence from even being used as in a court of law if this goes to trial.
That's correct. It's poisonous. It's tainted. Think of it as tainted. Think of it as tainted. And I remember learning about this in law school, Carlos, and it making so much sense, right? As to why sometimes we see things as the public, and we're like, well, clearly, I mean, it's on tape, or we saw it, or this or that, and how did they get off, and how did it get dismissed? I mean, we all know this happened. Oftentimes, it's through this mechanism. It's because, and this is why, if you're a Law and Order fan, or you watch any of these procedural shows, the way in which law enforcement on the front end, whether whether it's Stabler and Benson or whoever, how they go about collecting evidence is paramount. They must follow the rules and the book to a T, because if they don't, it could be the best case in the world, the most got them dead right, a center or whatever. And if they take one misstep, Carlos, if they don't have a judge sign off on the search warrant, or they don't have solid probable cause to enter the room, or enter the home, or enter the room, or enter the car, all that good evidence they got goes out the window.
And Raindrop. So I, of course, I was a junior in high school when the O.J. Simpson trial was around and the verdict came out. And I want you guys to really listen to what Eboni K Williams is saying, because everything is about reasonable doubt. And that's something I've learned watching the O.J. trial, because Raindrops, if you remember the glove, when Johnny Cochran said, if it doesn't fit, you must acquit. So remember, the glove was found at the crime scene. and the prosecutor used that as evidence. And the one thing was when they had O.J. Simpson with the plastic glove tried on the glove, the evidence was not thrown out. No evidence was thrown out in the O.J. trial. However, what Johnny Cochran and his team did was they cast reasonable doubt when the visual evidence of O.J. Simpson putting on the glove and it didn't fit. That cast a reasonable doubt. When Mark Furman, the police officer that seen the crime, when he was caught on tape saying the N-word, it cast the doubt of, okay, is the LAPD, and guys, remember, this is years after the Rodney King situation happened. So the LAPD, they were seen at that time as being a very racist department.
Hostile.
And Mark, hostile, thank you. So again, Eboni's cooking because it's not about whether or not it's true. If this does go to trial, let's say it goes to trial, what Wendy's lawyers doing is casting reasonable doubt on the onslaught just in case it goes to trial, but obviously they want this to be thrown out. I'm fascinated by this.
No, it's amazing. It's amazing. And like I said, it's not a deviation, Carlos, from how these things typically play out. As defense lawyers, keep in mind, and I am when I practiced, I was a defense attorney, but putting that bias aside, our job as defense attorneys is, the stakes couldn't be higher. We are normally dealing with life and or liberty of human beings. So we take an oath, we put our hand on a Bible, and we swear before God and government that we will do everything we can ethically do to zealously defend our clients and their interest. So Wendy's lawyer and any lawyer, frankly, worth their salt, should be doing something like this. Now, I'm not saying every single case, but generally speaking, why would you not try to challenge, the search and the seizure? And then if that's unsuccessful, then you essentially get a second bite at the apple, so to speak, once you get to the trial level. And now you're challenging, like you're saying, that prosecutorial standard of proof beyond a reasonable doubt. So you kind of get two opportunities, see what I'm saying here, to challenge this process. And if I'm the defendant, I want my lawyer to take every single opportunity to challenge what I am up against.
Yes. So now, Raindrops, the time you guys been waiting for, which is another fascination that I want Miss Eboni K Williams to really download and break down for us, is the fact that Wendy and Eddie have two separate lawyers, and Wendy's attorney wants elected to file a motion so that they can be tried separately. So with that being said, her husband, Eddie Osefo, he hired a powerhouse attorney, Joseph Murtha, who previously worked on a high-profile case involving former President Bill Clinton and Monica Lewinsky. Okay, so just so you guys know, he is a veteran trial attorney with experience in both state and federal courts, which I'm going to get Eboni to talk about the state and federal, because as of today, Wendy and Eddie's case is only state. It has not reached federal just yet. So just note that. However, Joseph Murtha represented Linda Tripp. Okay. Remember, Linda Tripp was the one who Monica Lewinsky trusted as a friend. Little did she know that Linda Tripp was recording the conversation. So in the case, Linda Tripp was accused of breaking the law when she taped the conversation with Monica, who we all know was involved in the sex scandal with President Clinton. So in his filing, Eddie demanded prosecutors turn over the names, once again, Eboni, of all potential witnesses they plan to call to testify against him. Eddie's lawyer asked that all charges be dismissed due to issues with the charging document, like the same thing with Wendy. Same thing. So they're doing the same thing. It's just two separate lawyers. Before we get into the lawyer and his background, the $1 million question is this. What message is Eddie and Wendy sending to the courts into the court of public opinion and being tried separately. Because a lot of people are saying Eddie may be trying to take the fall for this if it comes to that, because they do have 3 small children.
Sure. Yes. I mean, look, we can just kind of cut to the chase, right? There's much chatter that perhaps a strategy at play here is one co-defendant, in this case, Eddie, assumes responsibility, so to speak, of all of the charges, and said there was no conspiracy because conspiracy requires 2 people. There was no conspiracy. My wife, the co-defendant, knew nothing. If indeed there was foul play here, it's all on me. And he assumes all of that liability, that legal responsibility himself. That is being widely speculated. Is that possible? Sure. We've seen it before. It can happen. But 2 things. It's very important that Raindrops understand, even if that is the legal strategy Mr. Osefo, Eddie, and his legal team are trying to implement, and even if there's agreement from Wendy and her legal team, and this is how we want it to go, prosecutors are not bound by that, Carlos. So it's not as if there's optionality amongst the defendants to say, I'm volunteering to take all the weight here, just let her off, and then it just be that way, if that makes sense. The evidence is what must be evaluated. And then the judge and ultimately jury, if it gets to trial level, will decide if it's believable that, only one person, if any, are responsible here. But certainly, I just don't want there to be a belief, which I've seen, some people being confused. Like, oh, well, if he's willing to take the fall, doesn't that mean she's going to be okay? It doesn't mean that. It means that is a strategy that could be implemented. And then they will have to see how that plays out in front of said judge and jury. But that's not a sure thing, is essentially what I'm trying to say. It's no different than, I'm sure many of us know, back in high school or college, where the young lady's holding weight, so to speak, drugs for her boyfriend, and then she gets caught, and then he said, "Oh, Your Honor, she was running it for me, and don't worry about it. I'll take the rap for her." It don't go that way. It don't go that way. Once the facts are out, that is up to what we call the trier of fact, the judge and or the jury. It is not defendant's choice or co-defendant's choice the way these things play out. I just want to be very clear on that.
Yeah. No, I'm glad you are. So we understand that. So with that being said, him hiring this powerhouse attorney, Joseph Murtha, who was involved, Eboni, we're talking about the biggest scandal to rock the White House. Oh, yeah. I think in history, when it came to Monica Lewinsky and Bill Clinton. So
well, we went around for Watergate, but go ahead.
All right.
We thoughts in our parents' eye for Watergate.
Yes. No, you're right about that.
In modern presidential history, absolutely.
Yes. What message does that send to hire someone of his caliber to represent him in an insurance fraud case with a lawyer, Eboni, who is capable of representing him in the state, which is their current filing, but also in the federal. And if this reaches the federal, then baby, we're talking we're talking a big deal.
Yeah. We're talking a bigger deal, we should say, right?
Yeah, bigger deal. Sorry, yes, bigger deal.
No, you're right. Listen, to me, I actually think it says something very good, which is that they are taking this very seriously. Eddie, let me just speak to Eddie because that's the one, who's representing him. That means that Eddie is rightfully taking this, even at just the state level, which, to be clear, Raindrops, is certainly a less severe legal consequence than anything federal would be. To Carlos's point, everything just gets ratcheted up. And some Raindrops might be like, well, why is that the case? Let me explain. It is because the federal government, as we can see certainly very clearly in this administration, even more so than ever before, has almost unlimited resources when it comes to prosecuting claims. So that means there are infinity number of investigators, infinity number of expert witnesses, infinity number of all the things that the prosecution will need to prove their case, which is why federal prosecutors have over a 95% prosecution rate. Versus if you look at that of almost any state in the country, it is vastly lower because states are subject to what? State budgets. And so therefore there is a massive reduction of resources. There's only so many investigators that are at the helm of a state prosecution office. There's only so many expert witnesses. There's only so many rounds of appeal they can go. You see what I'm saying? So there's just a reduction of resources that are going to be at play at the state level, which makes it less severe than anything they could be potentially facing federally. But let's not get ahead of ourselves. As Carlos said, we're not even talking federal at this point, and we may never be. Let's be clear. It just, that dog might not hunt, because there are certain things that elements, or what we call them legally, Carlos, that the state requires that the federal, it could look totally different. I do want to just drop this for something for Raindrops to consider as well. Because these are state charges, that means the state government and political leadership have a lot of power here. And it's not lost on anybody that the current governor of Maryland is Governor Wes Moore, who we know has some, however casual or loose it may be, some relationship with, I know his wife, the First Lady Dawn Moore, has had some social acquaintances with Wendy Osefo. So just putting that out there as everybody's talking about Trump and Diddy or whatever, and all of these pardons and this, that, and the third, there is a political element that might enter this conversation at some point.
So I'm not sure if you watched last night's episode of Potomac.
I did not, but I did see the clip of Stacey speaking with Andy on Watch What Happens Live.
Okay, so the First Lady was at this like derby event. And
so she was actually in the episode last night. Oh wow.
I'm about to gag you. So long story short, the girls are being, housewives, a few of them being a little catty. And Wendy interrupts them and says, the First Lady's approaching, behave yourself. She puts her heels back on, and her and Giselle go to speak to the First Lady, and Eboni K Williams, the camera stopped, froze the frame, pointed an arrow at this person off camera, and wrote on the screen, the First Lady did not want to appear on camera.
Right. Not at all surprised. I was wondering how they were. So I only knew this because, full disclosure, I have not watched Potomac since the binder of it all, many, many moons ago. Love them all. And I, as you know, we have friends. We all have mutual friends who had literally been at events, and not this derby, by the way. So in addition to this derby, there are other social events, which makes sense because Wendy is a lady about town. She is running in the social circles of the socialites of Maryland. And so it is no surprise. And I'm not at all surprised, but I am a little gagged that they actually, and how they produced it, I guess, like you're saying. But yeah, so that's just something, again, not trying to overplay that, not trying to make any assumptions around it, but just something for Raindrops to consider, that because it's state, because if these were federal charges, the governor and everybody else can't do anything about it. But because they are state charges, there could be opportunity, if need be, for relief at that level.
I do want to ask you this before I let you go, because I'm just curious in terms of your thoughts, because a lot of people had a lot of things to say about this. So last week, Eboni, Dr. Wendy and Eddie both released their own personal statements. So prior to last Sunday, they had a lawyer speak on their behalf, asking for privacy as they figured this out. Last Sunday, however, they released a statement separately on their Instagram pages. I want to read you Ebony's, and I want to read you something that the
Wendy
audience.
style. Well, Ebony ain't made no statement. Wendy statement.
Well, Ebony did a caption on his page too, Ebony.
Oh, Eddie. Oh, I'm sorry. You said Eddie. Oh, okay.
No, it's okay. It's okay. Okay. No. So Wendy and Eddie both left
Okay.
a caption on their Instagram pages
Oh,
separately.
yes. Yes. Okay.
Okay. So I'm going to read you Wendy's.
Okay.
She posted a picture of herself, and the caption read, "And through it all, God remains faithful. Thank you for the outpouring of love, support, and prayers for myself, and most importantly, my family during this time.
Yeah.
We are forever grateful." Eddie also released his own statement, pretty much echoing their faith in God. What some people pointed out is this, and this is the $1,000,000 question: if this was purposeful and if it means anything. The raindrops and the audience said, in the statement from y'all joint attorney at the time, or representative, not attorney, y'all did not use the word "we're innocent." In y'all separate Instagram post talking about God, you both did not use the word innocent. A lot of people are wondering, why wouldn't they say, "We deny all of this and we're innocent," like they may have read in other people's statements? Is that something that cracks your curiosity?
Not really. And I'm going to tell you why. It's because if they're being advised early and wisely, I wouldn't tell my clients to make any statement of factual innocence at this stage. Why? Because it's not of service. It's not of service. What is that? Who does that feed? The peanut gallery, the folks in the comments? They're not in charge of my client's destiny or fate. And if you know what I mean? No disrespect, love you all, but baby, you're not the triers of fact. That is for your honor and the 12 ladies and gentlemen of the jury. And because I want all options available to me, Carlos, I just went through the ethics and the oath that we take, and I need to have all the bites at the apple, and I need to have all the plays on the table. That could include a plea. And it is all wholly possible. Let me just paint a scenario. Let's say I'll just use Wendy, random. Wendy and her legal team decide that the best legal interest for her is to enter into a plea bargain. It is possible that such plea bargain might require an admission of guilt. It's possible. I'm going to tell you about another kind of plea bargain that doesn't even require that in a minute. I'm going to gag you. Gag you right back, honey. But let's say that. Let's say one. You're so silly, Carlos.
I have my legal pad. I love it. Go ahead.
Honey, listen, we ready.
Yeah.
So let's say one requires an admission of guilt. You know what I wouldn't want is for my client to now look less credible, less believable, less truthful, because they're going to say, "Oh, well, that's interesting. Back in October, you said you were innocent, and now you're standing before the courtroom today accepting responsibility and asking for mercy from the court. Well, which one is it?" It's unnecessary. Now, I mentioned that there's another type of plea that doesn't even require an admission of guilt. It's called an Alford plea. I used to use these on occasion as a defense lawyer. An Alford plea, that comes from that's a precedent, that's a case. An Alford plea, Carlos, says that I could say, "Your Honor, I am entering into, on behalf of my client, Wendy Osefo, we're entering into an Alford plea," which says we're making no admission of factual guilt. We're not saying we did anything wrong at all, but we are saying that the evidence looks compelling, and we believe that legally and strategically it is in my client's best interest to not go to trial because the evidence is so compelling. Even though we're not admitting any actual guilt here, we're saying that the best legal thing to do is enter into a plea bargain. That is the beauty of an Alford plea. So it allows you to reap the legal benefit of a bargain with the prosecution, a predetermined deal, which normally comes with reduced sentence and this and that and other perks, but you actually do not make an admission of factual guilt, an Alford plea. So, but back to your question, those are all the reasons why I am not bothered or alarmed by the omission of a declaration of innocence at this stage of the game. That it literally served, it's of no service to either Osefo.
Listen, that's why I wanted to clear it up, because I thought the same thing. And at the end of the day, what's interesting, Raindrops, is this: by law, you're innocent until proven guilty. So, like Ebony said, it does more harm than good for me to do something for the court of public opinion.
Yes.
I'm going to behave in a way that makes me do things the right way in the court of law. And that's the difference.
Yes. Yeah. We're not playing crisis management, no disrespect to that important work, because it's very important. But the stakes are too high. The stakes are too high. They can worry about image rehabilitation and all of that far down the road. This is a time to be totally preoccupied with legal best interest. Best interest. Yeah, one thing at a time. Like I said, Raindrops, we're at the very preliminary stage. We have not gotten to anything substantive yet. That's why it is way too early to make any assumptions about substantive guilt or innocence. Are the charging documents even right? Is the evidence collected properly? Are the witnesses credible? That's the stage of the game we're at.
Ladies, gentlemen, gays and days, Eboni K Williams, thank you so much, sis, for breaking it down for us. And listen, we will be back, when more conversations and more talks about this occur. But in the meantime, guys, thank you all for tapping into this episode, and we'll see y'all in the next one.
Bye, my loves.